position paper, right, as I'd rather call it.
Yeah.
One of the contentions is that the Constitutional Amendment Bill of 2025 is flawed in that it doesn't guarantee a quorum of judges, right?
Okay.
Let's just unpack what exactly this is and why it's such a serious problem.
Okay. Well, first, let me say thank you very much for giving this opportunity to now speak and air these views since yesterday.
Yeah.
Didn't get that opportunity. So very much appreciated.
Yes.
Yeah. So, the quorum issue. Because it affects fairness, legitimacy, and public confidence. The bill sets no minimum number of judges required to hear a case. The discussion paper warns no quorum for the hearing of matters is set by the bill. So a matter could be heard by only one constitutional court judge. That's at page 10. And just to let everybody know that this document has been posted on the Facebook page of Bokongo, but sometimes it's difficult to find it because it's a Facebook page, because it gets sort of hidden and knocked down further down. Somebody asked me last night and they said they couldn't find it on the Bokongo page. You can also go to the Ditswanelo Instagram page, and person who asked me yesterday, I said, look at Instagram, and they immediately found it, on Ditswanelo, or Ditswanelo's Facebook page.
Yes.
But if you have Instagram, that might be a good idea.
So tell me, what's so wrong about...
So let me carry on.
Yeah.
What can go wrong if one judge hears a major case alone?
Yeah.
A major case, because these are supposed to be the major cases.
Yeah.
You know, the government has been portraying this as if this is going to be, when you go to Kotla meetings, you would be excused to believe that the Constitutional Court is going to allow the ordinary person sitting at the Kotla who has a property dispute with their neighbor to actually go to the Constitutional Court and somehow free of charge, or, you know, they're not even saying these things, but it's going to be resolved and quickly, and experts and they keep saying this is a specialized court, you know, we need a specialized court. That's another thing yesterday. Oh, I'm getting derailed because I'm going. So let me answer the question. One person could decide a human rights case with no possibility of an appeal. There will be no possibility of appeal because that's the way this Constitutional Court's set up.
Yes.
It's a court of first and last instance.
Yes.
So it goes there. So it's like saying now you will go to the High Court. There will be one judge sitting. It's the equivalent of that, and that's the end. No appeal to the Court of Appeal. No court, to any other higher court. The one judge, the one judge might have had a bad day or whatever. I mean, might not understand your issue.
Yes.
I mean, you might. Well, anyway. One person could decide whether an act of parliament is unconstitutional, and that would be the final word on it. Imagine. One person could decide the outcome of an election, and there'd be absolutely no right of appeal, because the Constitutional Court is now to hear all election matters, no other court, no appeal.
Yes. All
human rights matters, no appeal. This concentrates enormous responsibility and power in a single person, a single judge.
Yes.
And I don't think any single judge would actually want that. Sorry. Yeah. Okay. Is there a follow-up question?
Okay, so Bokongo...
Do you want to know what quorum were you going to... Okay.
Yes, what quorum was Bokongo thinking of wanting to be written into law? What quorum would be appropriate for Constitutional Court?
So I can see certain provisions were just this bill is a lot of just cut and pasting, really. But a lot of just clauses have been taken from South African Constitution and just shoved somewhere. So almost, and then but for some reason, the South African Constitution says that 8 judges, at least 8 judges, at least 8 judges must sit to hear a constitutional court case.
And that's a huge disparity.
It's a huge thing.
Okay.
So they are, the Zimbabwe constitution is a bit more nuanced, but I think it's somewhere between 5 and 7 or 4 and 7 depending on the matter. But probably, a minimum of 5 to 7 judges, I don't know, similar to South African's requirement. So yeah, a matter before the Constitutional Court must be heard by at least 8 judges. And that you can find that in the Bukonga judgment, the Bukonga document, page 10.
Yes.
The quorum must be written in the Constitution, not left to a future bill that may never be tabled. In fact, there is a bill that's floating around since August last night, and we don't know, which is a pretty scary bill as well, because it has some horrible provisions in it too about contempt of court and that, but let's not get derailed by that now.
Yes. Okay, so government says the new constitutional court is going to be able to protect rights faster and better. Some Botswana hear the words constitutional court and they assume that they will be given more rights than they previously have had, right? Why is Bukonga not convinced?
Well, we're not convinced because the bill does not strengthen a single right in Chapter 2. Chapter 2 sets out all the fundamental rights and freedoms, which are the human rights. Yes. Yeah, the Bill of Rights. It's called the Bill of Rights in South Africa, yeah. So it doesn't... If I can... This is not an exaggeration. This is the 100% truth. Chapter 2, all the bill does in Chapter 2, which is the Bill of Rights, it crosses out the words High Court and substitutes Constitutional Court.
Yeah.
That is all. I promise you, not a comma, nothing else happens in Chapter 2. You are given, it is introducing no new rights at all.
Yes.
It is not changing the interpretation of rights. It is changing nothing. The only difference is the court that hears the matters.
Yeah.
So the bill add no new human rights protections. The decisions will be final, as there will be no appeal. Okay.
Yeah.
And so which rights are strengthened? Well, all of them. So, for example, right to life, liberty and security, freedom of expression, freedom of assembly, privacy, property rights, protection of the law. The bill changes the forum, not the rights.
Okay, so if the goal is better protection of rights, what should have been included in this constitutional amendment bill?
So if the goal was stronger rights, the bill should have added clear interpretive, if that's what, because another thing, even last night again, we keep hearing the criticism of the current, this is actually the crux of the criticism of the current courts, is not that there's anything wrong with the judges or anything, but that the way they interpret the law is what they call constitutional avoidance. So in other words, if a matter can be decided other than on a constitutional issue, it gets decided on that rather than going to decide it on a constitutional matter. So, but in fact, there's a lot of merit to that, because it might be that the constitutional issue is not a major issue in that dispute, in that land dispute or whatever it is. But, and also, because it's not a major issue, the parties have not raised the issue. It's not been argued and aired before the judge to make a decision. The court, the cases, the existing cases, because remember, we in these jurisdictions, Commonwealth jurisdictions, we deal in it's precedent that you have to follow. Well, certainly you have to, unless a judge has to follow a previous judgment on the same matter, unless it can be distinguished on the facts or absolutely convinced that it's wrong, which would be a very brave judge to say that but they could decide something is wrong, but that would be very, very, very unusual.
Yeah.
Okay?
Yeah. So one of the other things that Bukonga is also worried about, right?
Okay.
Is
so clear interpretive principles like South Africa's constitution. Section 39, you can see at page 19 of the Congo, it sets out what, when you're deciding a constitutional matter, a Bill of Rights matter, what are the criteria you must look at? Do you have to, it says you have to look at the international law, you may look at foreign law, and you must, I could right now read that to you, but I'd probably just be wasting time. But in fact, so in the South African Constitution, it basically says when you're deciding a human rights matter, the Constitutional Court or any other court, not only the Constitution, must look at this is how they decided. So in other words, if you're worried about constitutional avoidance, then put something like that in your Constitution. But now everybody's crying about constitutional avoidance and telling everybody that's what the courts are engaging in, but there's nothing in this bill to direct the Constitutional Court to do anything different to what the current courts are doing. So how are they suddenly going to do that? It's I honestly don't understand the argument. Well, it's not that I don't understand it. I don't think there's any merit to that argument, unless if you think people are engaging in constitutional avoidance, then put something in the legislation in the Constitutional Court Amendment Bill or the Constitutional Amendment Bill to stop them doing that if you think it's a big problem. As I said, I think constitutional avoidance in many cases is a very legitimate thing for judges to engage in, because it avoids you having to decide the constitutional matter when it's probably not merited and you haven't got basically enough information to decide it in this matter. And you must remember, once you've decided, you're going to bind future cases. So you don't make constitutional decisions lightly. And that's why we have big quorums, going back to the quorum, so that you have a broad set of expertise, that any prejudice that might creep in on one judge is hopefully countered by another judge, one judge that might be slightly misogynist and somebody who might be feminist, hopefully they'll weigh each other up if you have a bigger quorum. And because we can't say just because somebody they don't have personal preferences, and I do understand a judge obviously tries to put all those aside, but we are frail human beings, and sometimes we don't even realize when our prejudices are affecting our decisions. And sometimes when we think we have prejudices, we might make a decision which is compensating for the prejudice and therefore gives us so I might think I'm slightly misogynist and therefore give a decision that favors the woman all the time, because I'm scared of my own prejudices, if you understand what I'm saying. Well, anyway, I digress, I think.
Okay. One of the other things that Bukongo is also worried about, right, is the president's influence in the appointment of judges, particularly constitutional court judges. What's the risk in the president having too much influence in the appointment of judges?
So, the risk of the president having too much influence is, as if you look at the constitutional amendment bill, you'll see that they haven't changed the way in which the Judicial Service Commission is set up. They've just added a few members, and these members are all appointed by who do you think? By the current president. Not just the president, but the current president. And this is yesterday as well that I couldn't counter, because I said the whole Judicial Service Commission, which is the body of people who basically who tell the president basically who he should appoint, are all appointed by the president himself. So, that's serious influence on the judiciary. And then also there's wording in the existing appointment provisions for the High Court and the Court of Appeal. It says that judges must be appointed in accordance with the advice of the Judicial Services Commission.
Yes.
Okay. Um, in this bill, the words "in accordance" are left out. Certainly for certain category. There are also many other problems if you read the document, because there's a whole class of judges, constitutional court judges, where we're not quite sure who's going to appoint them. But anyway, the ones that we know will be how they will be appointed. It says acting with the advice of the judicial service, so we have a very famous case, Mutamisi case, which a previous president ignored the advice of the judge to appoint a judge and refused to, and went to court, went all the way to the Court of Appeal. The court said to him, because of the wording, in accordance with, you are obliged to, you have no discretion. It tells you, you must do so. But now if you've left out the words "in accordance," you're now making it discretionary once again.
Yes.
So anyway, but even if that wasn't in, the fact that the whole Judicial Service Commission, except there's the Law Society appoints one person, but the decisions are made by a majority,
Yes.
a simple majority. So that doesn't really change it very much. And why would ordinary Botswana care? Because judges decide, once again, election disputes, human rights cases, whether government actions are lawful, whether Parliament has acted constitutionally, whether laws are constitutional. If the appointments are political, justice becomes political.
Yeah.
And we've seen it in other countries. I won't even mention, but I'm sure people know.
Okay. The Constitutional Amendment Bill also says that the Constitutional Court's decisions will be final, right?
Mhm.
Why does that worry you?
Because the court will have both original, so first, it will go straight to them, and final jurisdiction.
Mm.
There will be no appeal whatsoever. Even in cases involving life, liberty, elections, or constitutional interpretation. The discussion paper notes it is concerning that the Constitutional Court would have both original jurisdiction and final jurisdiction. There would no appeal. So that's really concerning, because basically, when you have a right to appeal, when you first take it to the court, and a higher court can review that. Firstly, a first instance court would be a one judge, so it's easier, less expensive, so you need less judges. Imagine 8 judges sitting, although you're tying up the courts, but you could hear 8 cases with one judge rather than 8 cases sitting at one judge. So only the most important cases should go to the Constitutional Court. But God, I think should have both original and final jurisdiction. So let me get back on path. Why should it both original and final jurisdiction? So one judge sits in the High Court. The case is aired, heard. It's reported to in the media. It's reported in Yarona FM, Duma FM, Gabs FM, RB2, whatever, BTV. This is what happened. I mean, they can't sort of comment too much on certain aspects of the case, and so people have, at the moment there's a high-profile case, as you know, two women, saying that they have the right to marry and the Marriage Act. Yes. So you have airing, you have public sort of participation and thinking, and then there's a decision, but that's not final. So now a higher court sitting with 3 judges or 5 judges or whatever it is, they then are able to look at that, and they're able to see what were the mistakes that were made. They can analyze it again. It's always easier to look at something in retrospect, isn't it? Yes. Than looking at it the first time. And you can see, so I think it's almost absolutely essential that you have appeal processes, that you don't just have one case, especially if it's one judge sitting. I mean, it's really, really, really dangerous to have perhaps one judge sitting and it to be final. and also we get that later, because the way this whole amendment is worded, I think the Constitutional Court, well, I'm sure the Constitutional Court is going to be overloaded.
Yeah. Okay. So one of the things that I really, really want to get into, especially because we have limited time, just a few more minutes left, right?
Oh, you're joking. Sorry.
Do you think government was honest and clear enough with Botswana before passing the constitutional amendment bill?
Well, was it clear and honest? Well, the short answer is no. Public consultation, how can you say that you're having public consultation after you've already enacted a piece of legislation? Especially when it's entrenched and has a 2/3 majority. You've already enacted it, and then you call that, how is that consultation? You are now campaigning for a yes vote. And that's the gist. I mean, that's what I saw last night. That's what I've seen. I attended early in the year, I attended at the Mass Media Complex a so-called consultation for the civil society groups, and we just had the minister talk for like an hour, and it was and very conveniently the same day as the budget was being read. So we were told, oh, the minister has limited time, gives his talk. Sorry, you're going to have to be really fast asking questions, and we're going to be limited. Asked about 5 people. I had my hand up, never got to me, like 5 people questions, and that's it. And the first person they asked was actually in favor, which was quite, but anyway, that now I digress. But given very limited time to make any comments, and then the minister was in a hurry, but then still went on and spoke and basically said that, people from the opposition have been planted to ask difficult questions or something like that. And I was like, what is going on here? Yeah. So I don't know. I don't think this is consultation. I don't know. But no, I don't think so. Yeah. And the public consultation focus on promised benefits, not the actual text of the bill.
Yeah. Okay.
And what does proper consultation look like? Publishing the full bill in accessible language, allowing civil society, lawyers and communities to comment, presenting both benefits and risks, incorporating public feedback into the final draft, holding consultations before, not after, decisions are made.
Yeah. So now that the bill has actually been passed and has moved forward, what is Bukhongo's next step? What would it take to see Bukhongo support the establishment of the Constitutional Court of Botswana, holistically, as a final question?
Well, you see, that's a problematic question because this is a no-sum game. Government has already decided that there's no compromise. This bill is going ahead. It's been passed by Parliament, and all that's needed is for the president to call a referendum. And unfortunately, the Referendum Act is another piece of legislation that is not fit for purpose. It was last amended, and I think it was just a minor amendment in 2001. It doesn't even say in the Referendum Act how you bring, it says the president initiates a referendum by issuing a writ to the Secretary to the Independent Electoral Commission. It doesn't describe how that actually gets brought to the public's attention even. Yeah. Imagine. It says a copy of if it involves legislation, a copy of the legislation must be attached to the question.
Yeah.
I have grave difficulty understanding how that works. Because the bill is quite a thick. Is every ballot going to have that attached to it? And that actually follows the Constitution, because the Constitution says, it doesn't say that you can. The question, if the question in the reference says, do you support a constitutional court? That, I hope somebody will take that to court, and before there's a constitutional court, and challenge it and null and void the referendum, because that's an unlawful question. Yeah. Because if the Constitution says that they must approve the bill. People don't approve they're approving the whole bill, and the bill has so many flaws. I mean, it has internal contradictions. For example, it gets rid of unlimited jurisdiction of the High Court, but high judicial office is defined as a court having unlimited jurisdiction. So the High Court now becomes a judge of the High Court will no longer hold high judicial office, which has other implications for for the thing. And the appointment of judges of the High Court, there's no criteria. It says the person must be a citizen and must be judge for 20, must have been qualified to be a judge for 20 years. What on earth does that mean? Qualified a judge where? What?
Mr. Eaton, I wish we could talk about this the whole day, but I just want to thank you so much for taking your time. If in one word, if you were to vote in the referendum that is to come, what would you vote? Yes or no?
N-O, capitals.
Thank you so much, Mr. Brian Eaton. Mr. Brian Eaton is a legislative drafting expert, and of course, I appreciate you taking out your time. I'm sure we're going to have this conversation again because we need to unpack the issues fully for Botswana to be able to understand, right? But of course, I appreciate your time.
Oh, thank you very much, and sorry for meandering a bit because I don't think we got through everything you wanted to get through. I'm really sorry, and thank you. For everybody who's listening and given their time to listen as well.
No problem.
Because I really appreciate it because this is such an important, probably the most. That's one thing I will agree with the panelists last night. This is probably the most consequential piece of legislation that's ever gone through the Parliament of Botswana.
Yeah.
And I hope people realize that. And then if there's a referendum, please go out and do vote because it's by a simple majority.
Yeah.
So if you don't vote and you want no, you're going to allow this bill to go through.
Yeah. All right, thank you very much. That's how we wrap it up for today on Point of Order. Coming up is a little special something. It's called Pewa Yasechaba. It's an all-new radio drama that's coming your way every single Wednesday from 6:50. Otherwise, it's a show where you and I get to explore some of the most critical issues in Botswana and to Botswana. We get to understand at an in-depth level how the things that are happening in our country affect you and I. What exactly is the issue? What does it mean for you on Botswana? What part do you have to play? All that is exactly what we're here to answer. Good night.
Point of Order with Soso. Wednesdays, 6 to 7 p.m. on Yaron FM. Live the music.
Oh.
I went on.